This is a public meeting, folks, so we are recording it so that you can tune in later or share with others, or other folks can catch it later. So my name's Bridget Budbill. I use she, her pronouns. I work for the Oregon Criminal Justice Commission. As noted before, and for the record, this is the Byrne State Crisis Intervention Program Advisory Board meeting. It's October 30th, and we have a couple of things to do today. The first of which is to take member attendance, and I know we have two members who will be joining us late. I know Jeff Howes and Senator Solman will be a little bit late, but I am going to take attendance for our other members real quick. So if you are here, if you could just let us know, we'll get that taken. So Judge Simmons, are you here? Okay. I don't expect to have Sheriff Morrissey O'Donnell here today. She said she couldn't come, but in case that changed, Sheriff Morrissey O'Donnell, I don't think so. Peter Klim?
I'm here.
Thank you. Jeff Howes will be late. Jen Fraga?
Here.
Thank you. Roy Moore?
I'm in attendance.
Thank you. Dr. Chisholm?
I am here.
Great, thank you. Let's see, Jess Marks? Don't see Jess yet. Okay. Erin Borla?
I'm here.
Great, thank you. Emily Watson? I know Emily was a maybe, so we'll check, see if she's later. Lori Palmer?
She's just coming in the room.
Oh, great. Lori, are you joining us today? Lori Palmer? Let's see. Lori might be on mute. So I'll come back to Lori. Councilperson Jones Dixon? Okay. Shannon Savell? All right, I'm not seeing Shannon. Do we have Representative Reynolds here? Representative Boyce? Kimberly Rose? Is that Kimberly?
I'm here.
Great, thank you. Dr. Carlson?
Hi, I'm here.
Awesome, thank you. And then Senator Solman, I don't think you're here yet, but we are expecting her a few minutes late. Senator Solman, you're not here, right? All right, I don't see her. So we'll check in on those folks in a minute. Lori, are you here?
Can you hear me now?
Yes, great, thank you.
Okay.
Awesome.
I don't think, can you see me also?
Let's-
No, I got a new computer here, so I thought those headphones would work. I'll work it out. Don't worry.
Perfect,
Let's
thank you. I
see.
can't see you yet, but
Okay.
but no worries. I'm glad you're
Okay.
here.
Thank you.
All right, so we'll get going. Thanks everyone for taking the attendance. Here's what we're up to today. First things first is the attendance, obviously. We're going to do a very quick kind of sketch of what this grant program is about and some of the federal requirements, just because, you know, it's been a minute, and we will revisit this when folks are actually asked to make some decisions or set some priorities, because there's a lot going on. The real focus of today's meeting is two presentations from our friends at the Secretary of State's office and the Oregon Judicial Department on one type of program that this funding could support, among others, and that is extreme risk protection orders. So we'll have Andrew Love and John Bennett from the Secretary of State's office, and Kimberly Rose, who is both a member of this group and a legal analyst for criminal programs at the Oregon Judicial Department, tell us a bit about various things that they've learned about our URBO program in our state. And then last but not least, we'll have a public comment opportunity and a couple things about our next meeting, which is currently scheduled for November 27th, which is the day everyone maybe comes back from Thanksgiving. So we might reschedule that if that's going to be a big scheduling snafu for everyone, and we might move that till maybe early December. So we'll ask for some input there. And as always, please just let me know if you have questions, raise your hand or just pipe up. I really don't mind either way. I really just want to make sure everyone has a chance to ask their questions. So a little bit of a reminder, what is this program we're all working together to support? It is called the Byrne State Crisis Intervention Program, and this comes from some folks in the criminal justice arena might know about something called Byrne JAG, which is Justice Assistance Grants. It's a pretty large, long-standing stream of funding from the federal government to states that can pay for all kinds of things like specialty courts or law enforcement training. It's really very broad. This in 2022, this is a new kind of funding, but it's a stream of Byrne JAG. It is separate funding, but it's kind of in the same realm. But it is specifically focused on firearm violence reduction. Because it's a federal program and not a state program, there are more kind of specific restrictions and requirements and things that we as the state administering agency have to do. But some very broad strokes. We, the state of Oregon, were allotted $3.1 million for 2022 and 23 combined into one lump sum. And then we will receive $1.5 million in 2024, 25, and 26, with the possibility that this program will be renewed going forward after that point. As we know now, sub-awardees, meaning folks or groups that the state funds could be spent or shared out to, include state agencies, local governments, federally recognized tribal governments, and community-based groups like nonprofits. And we will drill down into more detail in the future about kind of all the ins and outs there, but I just wanted to paint that as kind of a broad umbrella. Oh, and I see Senator Solman's here. Awesome, thank you. So some of the funding priorities, the Bureau of Justice Assistance, which is the federal agency that administers this grant to us, did set out 4 priority areas that they've kind of highlighted as maybe really good ideas that states could use this funding for. They're not the only things you can use it for, but they are sort of highlights. And I would say that these are the things that the BJA is sort of looking for. And if we were to do something different, that's okay, but we would just have to sort of make a case for it or justify why something different might fit our state better. I also want to emphasize that the funds can go to more than one thing. So you don't have to put all of your funding towards only one type of program. You could divvy it up across different types of program areas, just to clarify that. So the 4 priorities from the feds were extreme risk protection order programs, including trainings for law enforcement or courts or the public or victim services or anybody who might need some public information, including public information campaigns or publicizing best practices, kind of improving an existing program. One thing that this funding may not do, which isn't an issue for Oregon, but if your state did not have an existing ERPO program or red flag law, you could not use this money to implement a new one, lobby your state government to consider implementing this. And since we've had one on the books for, I think, about 6 years, that's not an issue for us. There are some other federal requirements around ERPOs that if our state wanted to spend that money this way, we'd have to show we have some things in place. But again, we can drill down into those kind of finer details once we get past the sort of bigger picture umbrella stuff. The second group of priorities in the sort of second bucket are court-based programs. And that includes things like gun violence reduction courts where either a client or someone who was a survivor of or a victim of gun violence could receive services through that. So existing specialty courts. I only know of Oregon having one existing specialty court that allows for folks with pending firearms charges to participate, but that might change. And one sort of things that's a part of my job is to bring that information back to you all in case you wanted to pursue something like specialty courts. We can give you an overview as to what exists. The other things that kind of fit into court-based programs could be threat assessment trainings for court personnel or judges, defense attorneys, prosecutors, implementation of validated gun violence risk assessments and other things, again, to support course-based programs. The third sort of larger bucket of priorities include behavioral health deflection programs. That could be community-based treatment, assessment programs, behavioral health, and civil legal responses like crisis mobile response, and then bigger ticket things like stabilization facilities. Now, $1.5 million a year for a stabilization facility. We'd have to be kind of creative as to how to support something like that, just to kind of keep things into perspective. But it is an eligible funding source. And I will get to this in a minute, but one of the things that we will do in the future, there are ongoing other streams and initiatives of gun violence reduction grants in our state. Dr. Chisholm is working on some of those, and we're going to explain kind of what we know is already existing so that this group can decide, well, we want to support programs that already exist, or maybe we want to fill some holes, things that our state isn't already doing. So just as kind of a flag for that. And then last in the sort of priority areas from the feds was funding for law enforcement agencies for safe storage, tracking, and the return of any relinquished firearms through existing kind of firearm seizure programs. So those are your 4 priority areas from the Bureau of Justice Assistance. We recently received some updated information from BJA as to other things you could do with this that don't fall into those, specific 4 funding priorities. And here are some of the examples they gave. Domestic violence protection order support. So good thing we'll have Kimberly here today to tell us a little bit about how ERPO exists, but also there are other domestic violence and other sort of protective order programs that sort of maybe work side by side ERPO or complement ERPO, but are not the same thing. Other things that BJA suggested included community violence intervention programs like hospital-based interventions, credible messenger programs, environmental design programs, and that is something I don't know much about. So if there are folks with questions or experience with this, please feel free to chime in. And then things like youth violence prevention for things like mentoring and community resources. So those are some examples there. And then they gave quite a few other ideas for law enforcement-based programs and technology, like gun locks, specialized training such as de-escalation or active shooter trainings, and gun buyback programs. And then last but not least, you can also spend all or some of this money on research and evaluation of the effectiveness of existing programs, such as ERPO or any other number of intervention programs that might already be working in our state. And I do want to say that for members of the advisory board, if there are ideas that you might like to pursue, please flag those for me so that I can make sure that the group, has a moment to consider those and potentially learn more about them, because this is not intended to be an exclusive list of all of the things that this could potentially support. So one really key piece of this grant that is very different, it's frankly pretty unique to federal grants, is there is an advisory board and you are it. Typically, the way we CJC administer federal grants is we run them through the governor's office and or our commission. But this program specifically required that a diverse group of people be seated as the advisory board to kind of oversee how the state funds are referred to BJA. So one of the things that is unique is typically the state is the decider as to where funds can go. It's either the governor's office says we want to prioritize specialty courts, that's where our Byrne funding will go, or the commission will do that. Here, our state gets to set its own priorities. We can allow folks to request funds through this program, but at the end of the day, the Bureau of Justice Assistance has retained the final decision-making authority as to whether they will allow us to release the funds the way we would like to. So that's why we kind of highlight the priorities they've set and also some of the other ideas that they've suggested, because at the end of the day, what we'll do is we'll learn together. We will set up some priorities after discussing where you think maybe some of these funds would be best dedicated. And then once we have some applicants, we will refer the ideas to BJA and then hear back from them as to whether they are going to give us the thumbs up that our funds can be released in the way that you've suggested. And please let me know if anyone has any questions about how that will work. That is how we understand it at present, and we do have ongoing technical assistance. So if we have questions that we can't answer, you can certainly call up BJA and get more information. One thing that I actually don't know at the moment, let's say, for example, the state of Oregon refers something to BJA and they say no. I don't know exactly what the reconsideration process is, but that is something I'm tracking down, in case that popped into your mind as well. So I thought I would sketch out some of the roles in case this helps. So what are we doing now? We're kind of gaining some background information on Oregon-specific firearm violence and injury issues. Once we've had a couple of meetings to go over this and talk, you'll be asked to set some priorities. And I think especially learning more about what our state's already funding might really help you see where there's room for growth and maybe room for supporting existing programs or what gaps exist. We heard a little bit from Dr. Carlson last meeting about some of our existing problems, but I think there's probably more conversation to be had there as well. And ultimately, you'll take all of this information and set some priorities for where you think some of this funding should go for now. And the other thing I think I iterated this before, but you also don't have to spend all 3.1 million at once. If you wanted to release a portion of that for something you're really sure about to begin with, you can also kind of withhold the rest and just keep talking about it. So there's no, as far as we know at present, there's no deadline by which you have to have made all of the decisions for the 22-23 funding. And I know this is a little confusing. I hope to have in the next meeting kind of a timeline sketch for you to see how we might actually lay this out over the next couple months. But at any rate, you will ultimately review requests for funding and then submit those up to BJA for their approval. What is our job as a sort of administering agency? It's to facilitate these meetings and to get you any information you need to feel informed. We're also on the hook for tracking updates from BJA just to keep up on these program requirements. One of the things, like I said, I'll be doing in the future is to see what already exists and kind of map that out for you. We'll also be developing the funding request process. So when folks want to apply for this money, we'll be setting up how they will do that, the application process. And then last but not least, making sure as many folks know who are eligible to do this, know that this is available and helping them apply and understand the process. So that sort of technical assistance and outreach to potential applicants. That's a really key part of our job. So that is my overview for today. Didn't want to belabor it too much. Does anyone have any questions before we get to our extreme risk protection order presentations? Don't see any. Oh, wait, Dr. Chisholm, go ahead.
Hey, Bridget, you could just call me Laura. Thank you. I respond much better to that. I spend less time looking over my shoulder. Just a quick question about the funding for 24, 25, 26. Is that $1.5 million for each of those funding periods, or is that spread over those three?
My understanding is that we are allocated $1.5 million each of those years. But I will triple check that. I'm fairly certain that that is $1.5 million each year, but I will double check it. And then we have heard from BJA that there is a pretty high likelihood that this will be renewed, which is nice because it takes a little while for programs to get implemented or to kind of hire up new people if that's what you're doing. And it's nice to hear that this might exist beyond just a couple of years as things are starting to get rolling. Senator Solomon, go ahead.
Thank you so much. I appreciate this. My question has to do with, do we know, is there some sort of document or some sort of information that we're looking at bills that we have passed and where they are in the implementation and where we see, maybe significant gaps or in any way, in that way? Is there something that's looking at each of the bills that we have taken action on in the state of Oregon?
Senator Solomon, that's a great question, and that is kind of what we're hoping to build. I know of existing in the past DOJ community-based violence intervention grants. I know of an OHA-based grant program that Laura is working on, but that is something I'm hoping to build so that we do have a more complete view as to kind of where we are in these initiatives so that we can overlap where you like to and fill gaps where you'd like to. Let's see, I see a hand. Jess, go ahead.
Yeah, this is really just a follow-up to that question, and just to clarify that this funding should be used around education and programming, not necessarily to do those kind of fixes. Is that correct? Because, for example, in some of the ERPO work, there are recommendations out of state offices, et cetera, of changes that ideally need to happen.
Yes, you're exactly right. There are pretty strict prohibitions on anything that could be construed as lobbying or advocacy. So trying to change an existing law, we can't use money for that. You can use funds to educate the public or the personnel or sort of subject matter experts who have to perform the work. But strictly speaking, we can't use it to go educate our legislators. Luckily, we have many legislators who are on this board and can bring what we learned back to that body. And I also saw that Rep. Reynolds has joined us, so thank you very much. Are there any other questions? Oh, go ahead, Rep. Reynolds.
Hi, sorry for the confusion. I was here from the beginning, but I was on my phone, probably driving back like Senator Solomon was from an event. I think that's a great point, Senator Solomon, and I think it would be good to know where we are. And then also I'll do a plug, which I think Jess was alluding to, which I'm super excited that we have our auditors here to talk about some of the shortcomings in ERPO. But that's all. Thank you.
All right, I'm not seeing any other hands at the moment, but like I said, please just pop up when you can. If no other questions, we'll get started on our today's presentations. First up, we have our Secretary of State's office, Andrew Love and Jonathan Bennett, and they are going to tell us about their advisory report from August. So I will stop sharing and allow you folks to do that. And let's see here. We have Andrew. I see Andrew and I saw John earlier. Can you folks go ahead and share? Is that going to work for you? Okay,
Yeah.
perfect.
Yeah.
While John is setting that up for us, I will do a little bit of an introduction on this audit and who I am. I am Andrew Love, Secretary of State, Performance Audit Manager. Been with the division for over 20 years now. Have experience of doing wide range of audits, primarily in the education field, and that's interesting enough how this review kind of got a start to it. We were looking at school safety, and then with the issues or the things that occurred with George Floyd, we kind of took a turn to look to see what we could do in terms of looking at gun violence. And part of one thing I want to explain is that this is not a typical audit report. This is what we call an advisory report. The differences between those is the detail of which we follow our generally accepted government, I'm going to get that wrong, our government auditing standards. It's GAGAS is the acronym. And part of why we choose advisories is dependent on whether there is an actual auditee. So for instance, this is not necessarily a program where one agency is responsible. In that sense, we wanted to take a look at the program, but didn't want to be limited by the fact that there was no agency responsible for it. And then the other aspect of it is there isn't any recommendations on this report. This was really about answering kind of 5 big questions that we thought were out there about the ERPO. Partly we didn't have recommendations, and because of the legislation that was going on when we started this audit, we felt that we wanted to leave that alone and just touch on a topic that doesn't have a lot of information out there. So I will hand it off to John, who did a lot of the work here. He's our ERPO guru, I would say, in the office. I don't know if he would agree with that title, but I will hand it off with him. But I will stick around and help answer some questions. Go ahead, John.
All right. Can everybody hear me all right? Is that a yes?
Yes.
Yes.
Okay, good. Awesome. All right. So, so Andrew, thank you so much for the introduction. So as it was noted, my name's John Bennett. I'm a senior performance auditor, and I was the lead on this project. So I'm excited to have an opportunity to share what we learned. I want to lead off a bit with why we did this advisory report, and I think Andrew touched on that really well. I'll just hit a couple of other points. One is that firearm-related deaths are on the rise, both nationally and in Oregon. Andrew brought up the George Floyd issues. We also started work on this report soon after the tragedy in Uvalde, Texas, and actually soon after the Bipartisan Safer Communities Act passed, which the funds you guys are discussing sort of flowed out of. So it seemed like a good opportunity because both those kind of raised the profile on ERPO laws or red flag laws. So we wanted to provide an opportunity to provide some information on those. And then Oregon is one of 21 other states and the District of Columbia with these laws. And we just wanted to be able to provide a bit of a comparison on how Oregon's law works compared to those two. So as Andrew noted, we organized this report around kind of 5 key questions. What is Oregon's ERPO law and how does it work? What state and local entities are involved? How is it being used and is it working as intended? How does Oregon's ERPO law compare to best practices and similar laws in other states? And then finally, what resources are available to law enforcement and the public to learn more about the law? Before I get started on kind of my answers to those questions, I wanted to just add a little bit of context. I know that you all received some information on this in a prior meeting, but it's just useful context, I think, to get us started here. So this chart shows a comparison of Oregon and the United States as a whole's age-adjusted firearm death rates. That's essentially the rates are per 100,000 individuals. And the key takeaways here is that Oregon's death rate over these 4 years is roughly the same as the nation, but the distribution between homicides and suicides is a lot different. Oregon has had in that period less than half the homicide rate, but a considerably higher firearm suicide rate. And I just want to note that this is on the suicide side. This is really important because firearms are far more lethal than other means. So reducing suicide attempts with firearms is really critical for reducing incidents of suicide overall. And ERPOs can be a tool to help with that. So we'll just start off with what is Oregon's ERPO law and how does it work? As Bridget noted, Oregon's ERPO law went into effect in 2018. At the highest level, an ERPO is a civil court order that in Oregon can be requested by a family or household member or a member of law enforcement that is designed to prevent a person at risk of hurting themselves or others from having or getting deadly weapons, particularly firearms. The fact it's a civil order is important. This provides an ERPO to be used to keep people safe and prevent tragedy without the kind of long-term negative effects a criminal case can have on an individual and their life. In Oregon, ERPOs require clear and convincing evidence that the respondent is at risk of suicide or of causing physical injury to another person. That clear and convincing evidence is a sort of a burden of evidence standard. And then finally, ERPOs should focus on individuals exhibiting dangerous behaviors and not specifically to those struggling with mental illness. And in fact, Oregon statute specifically bars courts from including in their findings mental health diagnoses or connections between the risks presented and mental illness. And I think that's important because we want to avoid further stigmatizing individuals with mental illness by targeting gun violence prevention policies towards them. Studies have shown that most individuals with mental illness are not violent, and further, individuals with serious mental illness are more likely to be victims than perpetrators of violence. So it should be focused on behaviors. This chart in hindsight is kind of an ugly flowchart of what Oregon's ERPO process is. And I'll lead off with a few definitions. So petitioner, when I say petitioner, that's an individual who's requesting the court to order an ERPO. And then a respondent is the individual who is the subject or potential subject of an ERPO. And then the last term, I don't know how many lawyers are in the room, but I'm not one, so I didn't know what this meant when I started. But you'll see the term ex parte in here quite a bit, referring to hearings and orders. Some other states call them emergency orders, but it's essentially a short-term motion that can be am I still there? Oh yeah, it's a short-term motion that can be done with just the petitioner and the judge. It's granted without the respondent there. So as far as the process goes, an eligible petitioner will file a petition in one of Oregon circuit courts, and then the court will hold a hearing, typically the same day or the next day. And at that point, the judge will determine whether there's enough evidence and risk and will either issue the order or deny the order. If the order is denied, process is done. But if the judge does issue the order, it first will need to be served to the respondent. That's typically done. Well, I don't know if I can say typically. That's often done by county sheriff's offices because they do it at no cost. And once the respondent is served with that order, they must surrender all of their firearms and concealed weapons, and any concealed handgun license within 24 hours. At that point, also the county sheriff's office will input data into LEDs at the state level and NCIC at the federal level, and this allows law enforcement in other jurisdictions to be aware of the order, and it is also the mechanism that ensures that that the ERPO will show up on a background check if somebody attempts to purchase additional firearms. So at this point, the respondent has a choice, and Oregon's actually unique in this regard. In most other states, the final hearing is assumed to happen, but in Oregon, the respondent has a choice. Within 30 days, they can either request a hearing to challenge the order or not. And if they don't, the order will go into effect for a full calendar year. But if they do request a hearing, that hearing must be held within 21 days. I didn't include it on the slide, but any eligible petitioner can request an extension of an ERPO if the risk is still present, as long as they file that within 90 days of the order's expiration. This slide outlines the risk factors in statute that can be used to determine whether an ERPO should be approved or not. I'm not going to go through them in detail. There's a lot of them here, but I just want to highlight that they're focused primarily on current or past behaviors, risky behaviors of that individual. Few other highlights about Oregon's ERPO law and how it works. It's a Class A misdemeanor to violate the terms of an ERPO as a respondent. And in addition to the penalties that come along with that, they can also be forbidden to possess a firearm for 5 years afterwards. It's also a Class A misdemeanor to petition for an ERPO with the intent to harass the respondent or to knowingly file false information. So the petitioner needs to be filing this in good faith. Overall, the process is relatively similar to that used for the other civil protective orders in Oregon, like the family abuse protection order or sexual abuse protection order. The overall flow of the process is similar, except for, this is interesting for ERPOs, most of the other protective orders, if they have a firearm surrender component to them, have a more robust process for documenting that surrender. The respondent's required to file a declaration with the court saying where those firearms went, whether it's a friend or a family member or a gun store or law enforcement. And the ERPO statute does not have that requirement. And then I'll end just by saying that ERPOs are a relatively new public policy tool for reducing incidents of gun violence, but the initial research findings have been encouraging in terms of suicide reduction. There were studies in Connecticut and Indiana that found that, and then also some more recent studies sort of finding examples where ERPOs were filed in response to threats of mass violence.
Hey, John, looks like we have a hand raised.
Oh, I can't see the hands. Thanks, Andrew.
Yeah, I'm monitoring. That's my job.
Hi, this is Jess again. I was just hoping you would expand a little bit on, and maybe you are later, so if I'm jumping ahead, please feel free to let me know, on recommendations around that fix around documentation.
I can jump in. I mentioned this in the beginning of the report, but we do not have any recommendations. Again, usually we have recommendations when they're pointed to a particular entity, and we felt it would be unfair to just throw out recommendations to the world. So there isn't any specific recommendations. We're hoping that stakeholders, legislators, governor's office, whoever, can take a lead in to determine how to address that issue.
Great. If there's no other questions, I'll go along here. So the next thing we wanted to
John, we
to
do
provide...
have one more question.
Oh, okay.
Sorry to interrupt.
Awesome. Thanks. Yeah, sorry.
Hey, this is Kimberly Rose. I just wanted to follow up on the question about the dispossession protocols. Those were set in statute, and that was enacted into law in House Bill 2013 that was passed in 2019.
Great.
Go ahead, John.
Awesome. So as far as the state and local entities that are involved, so I've hit this a bit. So the circuit courts play a key role. Judges in circuit courts will hear the cases, and they'll hold both the ex parte and the final hearings and determine whether the petition meets the legal threshold. Sheriff's offices play a key role, serving the orders at no cost, inputting data into LEDS and NCIC. Also, as local law enforcement, they can be petitioners. Municipal law enforcement can also be petitioners. At the state level, the Oregon Judicial Department sort of administers Oregon's statewide court system, and they've created forms for kind of all steps of the ERPO process and information, and then a sort of uniform process to use throughout the state. OSP has a somewhat limited role, but they do administer that LEDS database. They also have a unit that's responsible for firearm-related background checks, so they're somewhat users of that information. And then troopers, again, as law enforcement, could be petitioners for orders as well. I'm not going to go through them in any detail here, but the report does have a few non-ERPO state-level efforts to address gun violence through the Oregon Health Authority, the Department of Justice, and then I think we highlighted some of ODE's suicide prevention work in there as well. I don't want to belabor these points too much because I'm pretty sure that Kimberly's going to hit this and probably with more up-to-date data, but we did want to look into how Oregon's ERPO law was being used. This chart shows sort of the distribution between the different petitioner types. And as you can see, law enforcement is the majority of requested ERPOs, and then the filled bar is what percentage of those were approved. So law enforcement has requested the most, and most of theirs are approved at that ex parte stage. Family or household members, still a sizable portion, and a lower approval rate at that ex parte stage. The other in here, I don't want to belabor this too much either, but this is where actually petitions filed by petitioners who weren't eligible. I think there were 48 of them in there. The takeaway from that to a certain extent is that we took that as maybe a bit of an indication for more public awareness being needed, because individuals were going through the process of filing these without actually being eligible petitioners. We did take a look to see how often respondents were taking advantage of their ability to contest the ex parte orders, with some help from Kimberly. Based on our analysis of that, only 19% of respondents actually requested that final hearing to challenge an ex parte order. But at the same time, those challenge ERPOs were upheld for a final order 54% of the time. So that's quite a bit below the percentage that they were approved at that ex parte stage. So our conclusion from that was that the ability to challenge an ERPO seems to provide respondents a legitimate chance to contest an order, but few respondents are taking advantage of that. I won't spend much time on this slide either, but this shows kind of the raw counts and normalized by population count of ERPOs by county in Oregon. There were 6 counties that didn't have any ERPOs requested in the period. They were 6 of the 7 smallest counties in the state. But the primary takeaway from this is the wide range of use of ERPOs between counties, among counties in Oregon. Of the larger counties, you can see Josephine had 52 ERPOs requested per 100,000 residents, whereas Lane County only had 3.9. And our kind of takeaway from that variation is that it could indicate differing levels of familiarity in ERPOs, both among law enforcement and the general public by county. I'll also say that other states with ERPO laws show similar variability in ERPO use by counties. This slide just shows the kind of how many orders were requested by the different protective order types. And really, I just wanted to note less than 1% of all the protective orders filed between 2018 and 21 were ERPOs. You know, from some of the stakeholders and other individuals we spoke with, they kind of saw ERPOs as filling a gap that some of these other orders may leave in some cases. So the relative low use wasn't as surprising to some of them. So that kind of answers the first part of this question, like how is it being used? But the second part of if it's working as intended is a little bit more difficult to answer. At a functional level, it appears that appropriate petitioners are filing them, the courts are using it in the appropriate way, and those sorts of things. So it appears that the law is working as it was written. But basically, to really know whether ERPOs are effective at reducing gun violence in Oregon, there needs to be more research and evaluation to be done. OJD does collect and disseminate information on these. That's where we got all the information for those prior few slides. But researchers from organizations like the Consortium for Risk-Based Firearm Policy highlight a need for more detailed information, like demographic information on petitioners and respondents, more details on why orders are filed and their circumstances, information on specifically on firearms and those sorts of things to really evaluate their effectiveness and as well as the equity of the law. And I just want to be sure to note that the Oregon statute doesn't have any requirement for information gathering or evaluation. So it's not like a missed, it's not that things that are supposed to be done aren't being done. It's just it's just what it is. We did get some demographic information from OSP out of the lead system. This was for all active ERPOs as of, it was a date in late December. So it's just sort of a snapshot. And based off this, you can see the majority or the sort of vast majority of ERPOs are for white individuals, males, as well as sort of individuals younger than 45. This is too small of a population and just one snapshot to really draw any strong conclusions from it. But I just wanted to share that we were able to get some of that information. From our research and discussions with stakeholders, we did identify some barriers faced by petitioners and respondents for the process. The first is time. It takes time to fill the form out, go to court, potentially multiple hearings, and that has costs associated with it, whether it's lost wages or childcare or transportation or those sorts of things. So time can be a barrier. Lack of familiarity with court processes. Court can be intimidating for people who aren't used to it. So that can be a bit of a barrier. It's a civil process, so there isn't, there's no right to an attorney or those sorts of things. You can have an attorney, but one isn't provided, and those kinds of things. Lack of awareness of the law was cited as a barrier from some individuals. It's difficult to request an ERPO if you don't know that the law exists. And then language barriers can be a barrier as well. OJD does provide the ERPO form in Spanish, but it does need to be submitted in English. The court process itself will be done in English, although interpretation services are available, but that's just another potential barrier. And I want to note it's likely that lower income individuals or individuals from traditionally underserved groups probably feel these barriers more acutely than others. Law enforcement, we were, especially from the county sheriff's offices we spoke with, ERPOs are similar enough to other orders and are rare, so they didn't really feel much of an administrative lift from them. But they did highlight the risk, particularly in serving the order. You're serving an order to somebody who's been identified as a known risk. So there's some risk involved there. And then that lack of mechanism to ensure that the firearms were surrendered can present a bit of a risk. And then that 24-hour period between when the order is delivered and when the firearms have to be surrendered also just produces some risk. As far as how Oregon's ERPO law compares with best practices and similar laws in other states, as I noted, there's 21 other states with these laws. And Oregon has some interesting distinctions, I suppose. it has the highest burden of evidence, that clear and convincing evidence standard for the initial ex parte or emergency order period. Michigan also has it at that high of a level. Most other states have a lower initial level, preponderance of evidence or good cause or probable cause, and then escalate to the clear and convincing standard for the final orders. As I noted before, Oregon's unique in only in having that final order hearing be optional. As far as duration of the emergency orders, Oregon, along with California, has the longest of 21 days. Most states, that period is less than 14 days. And then in terms of eligible petitioners, Oregon and 15 other states have that family or household member and law enforcement set of eligible petitioners. Some states have fewer. Florida only allows law enforcement, for example, and then other states allow more types. So California, for example, allows employers, healthcare workers, and school personnel. Some other states allow mental health care workers specifically. So there's some variability there as well. Compared to best practices, and we got our practices from organizations like the Giffords Law Center. Again, I mentioned the Consortium for Risk-Based Firearm Policy earlier, and there's also some federal model legislation as well. But compared to these practices in some other states, Oregon does have less robust firearm surrender procedures. Recommended practice is to request immediate surrender of firearms. And then also the availability for law enforcement to request a search warrant if they don't feel that all the firearms have been turned over to them. Oregon also lacks protections for minor respondents. Protections like confidentiality of the court records or additional support. That's not explicit in our statute. And I'll just note that Washington's ERPO law contains both of these elements. The AP did a study of, well, not a study, they did a survey of ERPO use by states through September of last year. And Oregon's about middle of the pack compared to the other states when you normalize it by population. Main interesting takeaway from this is that Florida has by far the most and only allows law enforcement to petition for them. And then I'll end with just a discussion of resources that are available for both law enforcement and the public. So on the public side, OJD provides detailed information on their forms and instructions that are useful for petitioners and respondents. DOJ has an informational webpage and kind of a one-pager fact sheet that are useful. Nonprofits, I won't hit them all, but Legal Aid of Oregon and OCADSV provide significant information on ERPOs and other protective orders. But in our interviews, this sort of lack of public awareness was regularly cited as a barrier for sort of increased or more effective ERPO use. And some other states have provided more resources than Oregon. California set aside $10 million for increased awareness. That was primarily through community-based organizations. Colorado created a centralized Office of Gun Violence Prevention to kind of organize their response. And then Illinois created a public education campaign through its Department of Health. And then on the law enforcement side, similarly, we were told by multiple stakeholders that there's need for more law enforcement training on ERPOs. The Department of Public Safety Standards and Training, that's DPSST, doesn't have any statewide or regional training on ERPOs. But then just to highlight kind of a potential success story, there was an officer in the Bend Police Department that found kind of ERPOs to be useful and developed some training materials and provided them across Deschutes County. And now that county has one of the highest numbers of ERPOs. So that's sort of an indication that more awareness and training could lead to more use. And similar to the prior slide, there's some other states that have required or instituted some more training for law enforcement. Like Illinois is requiring a yearly training on ERPOs for law enforcement, or at least they were at the time of our report. So that's everything that I have. Let me go to my question slide. I don't know if I used up all my time or not, but I'm happy to answer any questions or can wait until later. But thank you very much for the opportunity.
Thank you very much, John. Does anyone have any questions at the moment? Go ahead, Senator Solomon.
Thank you. Thank you so much for this information. A couple of the things that have just kind of came out to me and I thought about when you talk about who has access to this information, and you said really just the lack of information. Do we know if this is involved or intertwined when 988 or the egg suicide line is called or the restraining order is processed? Do you know if folks get this information to be able to say, here are some of the tools that you're able to utilize to continue to keep you or your loved one safe?
You know, that's a good question. I don't have any like specifics on that. I would say that many of the other protective order types do have a firearm surrender component to them. So the, you know, if there's a you know, hypothetical family abuse protection order is filed and you are concerned about kind of gun violence from that individual, an additional ERPO is probably not necessary because that firearm surrender is a common component across the others if needed. But as far as 988 and suicide prevention goes, I don't have any details on that at this point.
Okay. And my second part to my question was, I'm just curious, because this is a civil process and not a criminal process, does this show up in the lead system to where people can see who has this?
You know, it certainly shows up on, like, if somebody with an ERPO went to a gun store and tried to purchase a gun store, it would the whole store tried to purchase a gun. It would show up on that record. But you know, that's another thing that I'm not 100% sure on, but I may be able to follow up on that. It shouldn't show up as a criminal record because it's not a criminal record. It's a civil matter.
Right.
But I don't know exactly how it looks.
Okay. All right. Thank you.
Mm-hmm.
We have another question, John.
Okay. Oh.
Representative
Reynolds?
Reynolds.
Hi, thank you. I thought this report was really excellent, so thank you so much. It's great work. And I hope it does inform some of our discussions here. Do you all have a feel for how the surrender or verification of surrender of the gun goes in other states? And my understanding is even in Oregon, in situations where you are supposed to surrender the gun, that's probably not happening as it's probably not being verified as consistently as we should be.
Yeah, I can say that at least within Oregon, it appeared as though some of the county courts are requiring that firearm declaration that's required for the other protective orders, but not all of them. And it's not, and that isn't required statewide. I think the best example that I can point out, and the report should have it in there, is Washington statute has these immediate. So law enforcement shows up and it's an immediate turn over all of your firearms, and then they have an avenue to request a warrant if they have concerns. There's some other interesting components to Washington's process, like on the actual ERPO form itself, the petitioner there's an opportunity for them to say like what guns they think the person has and provide some details around that. So there's some idea of what should be expected to be turned over. And then also Oregon does allow you can surrender your firearm to anybody who can legally possess a firearm. So it could be a friend or a family member or to law enforcement. And I believe, I'd have to verify this again, but I believe in Washington, those surrenders go to law enforcement. Like that's who receives them. So there's not that kind of question mark about where they ended up.
Thank you.
Mm-hmm.
I see a question from Jeff. Oh, sorry. Go ahead.
I just was going to confirm the question. An ERPO does show up in LEDs. Yes, right at the top.
Oh.
Thank you. Do we have any other questions for Andrew or John? And we can also ask them more questions. I do want to give Kimberly Rose from OJD ample time to do her presentation as well. So seeing none, Kimberly, please go ahead and share your screen. Kimberly Rose is a legal analyst for criminal programs with OJD. And she's going to tell us more about sort of the specifics of Oregon's ERPO data through the courts. Thank you.
Hi, good afternoon, everyone. My name is Kimberly Rose. I use she, her pronouns. I am a legal analyst for criminal programs with the Judicial Department, and I would just like to confirm that you can see my title screen. Okay, great. And Bridget, I would ask that as we go along, if there are questions, if you could let me know. I'm not able to see the whole group.
Can do.
Thank you. So today I'll be covering data that the Judicial Department has on ERPO cases. We'll talk a little bit about some background information on the data before we get into specific data on ERPO cases. And there's space at the end for questions, but if you do have questions as we move along, please go ahead and ask them. So as Jonathan mentioned, circuit courts are the entity that determines whether to issue an ERPO and also the record keeper of ERPO proceedings. The data covered in this presentation was gathered during a review of those cases that were filed from when the law first went into effect in January 2018 through September 2023. I began doing an individual review of these cases in 2018 as a way to assist with judicial education and gain a better understanding of how the law was being implemented. Gathering this information has also been helpful to respond to inquiries from the media and the public. And while OJD does have quite a breadth of data available on demand through internal data dashboards, and that can be obtained while querying our case management system, we don't typically review individual cases to gather data, in part due to the volume of cases and the staff time required to review those cases. This is a level of review that's not required, but it's something that OJD thought was important given the level of interest in these cases. And whenever I talk about data, I always like to include the caveat that data is not static and can change over time due to further court action. This can happen in ERPO cases, but it's less likely than other case types like criminal. And some of the data sets that Jonathan talked about, I'll be covering as well. My data looks a little bit different, and that's just because at the point in time in which that data was captured. The data that I looked at was captured within the last several weeks. So the Judicial Department developed tools in response to and for implementation of ERPO that help to provide some statewide consistency for these cases. Oregon law actually directs OJD to develop forms for these cases, and those forms are available on our website and at the courthouse in English and Spanish. Additionally, interpreters are available in all language for court proceedings, and court staff can use the language line if translation services are needed at the courthouse counter. The forms include a set of instructions that generally describe the ERPO process. However, it doesn't provide legal advice, which is something that court staff are prohibited by law from doing. We developed statewide business processes to provide guidance to court staff on what codes to use when entering events and documents for these cases into our case management system, and also created a distinct case type for these cases so we can track filings. And we also have developed educational resources for our courts that include bench cards and guides, lunch and learn sessions on protective orders, and ongoing trainings. Those ongoing training topics aren't limited to protective orders. They also can include domestic violence and state and federal firearm restrictions. Jonathan did a really nice job giving you an overview of the ERPO law, and so I won't go into detail on this slide. The only thing that I would mention is that, as you know, these cases require clear and convincing evidence, and that's basically evidence that proves a fact substantially more likely than not. It's like a medium standard of proof, a little bit more than preponderance, but less than beyond a reasonable doubt. And the ERPO law applies to more than just firearms. It also includes all deadly weapons, although we generally talk about it as applying just to firearms. And I wanted to, as we get into the data, I wanted to start by looking at how ERPO case filings compare to other protective order cases. And one thing that's in the Secretary of State's report is they have a nice chart in there that highlights the similarities and differences between ERPO and other protective order cases. And each protective order has its own distinct purpose, and there can be overlaps on what those orders do. And I do want to thank the Secretary of State's office for their report. We worked with them on providing information for their report, and they were just really lovely to work with in that process. So consistently in Oregon, the largest number of protective order cases by far are your FAPA, your Family Abuse Prevention Act protective orders. There are about 9,500 per year. Case filings significantly drop. And then the next most common types of protective orders are EPDAPA, which are your elder abuse protective orders, and stalking. And then there's another drop off to SAPO, which is your sexual abuse protective order, and ERPO. These two are the newest types of protective orders. SAPO went into effect in 2014, ERPO in 2018. But these two protective orders have very similar case filing numbers. If we look specifically at case filings for ERPOs, we can see that filings have generally increased since the law went into effect in 2018. One thing that's really was interesting to note is that there was not a decrease in case filings here in 2020. That was different from many other case types, including FAPA, EPDAPA, and stalking. We saw that with felonies and misdemeanors as well. As you know, that was the year of COVID, and so across the board, almost all case filings decreased, but we did not see that with ERPO. So the general trend on ERPO case filings is that it has been increasing. My best forecast is that we'll see around 180 cases this year. As of last Wednesday, another 11 cases have been filed in October. And as I sat with the data and trying to think of what's really driving this increase, I think one of the contributors is that law enforcement in some counties, particularly Deschutes and Clackamas come to mind, have really been utilizing ERPO more over the years. And I wanted to kind of give you a picture of what the case filing trends look like in certain counties. This dark line here is Multnomah County. And generally in my office, when we talk about case filings, we'll generally say Multnomah has about 30% of the statewide case filings. That's not true with ERPO. However, when the law went into effect in 2018, Multnomah had about 15 cases, and they were kind of one of the leading counties that year. However, filings have very steadily decreased since then. Washington County, that's this next line that's been added. They also tend to have a large number of case filings, and they started out having a large number of ERPO filings. However, their filings have decreased as well, although not as much as Multnomah. We've talked a little bit about Deschutes, and this is the one county. They started out in 2018 with 2 cases, and they've shot straight up, especially I would say since about 2021. And they've had 31 cases so far this year, at least through September. And of those 31 cases, 26 were filed by law enforcement. A little bit similar. Yes.
I'm sorry, we have a question from Senator Solman.
Sure.
If you want to wait till the end, I'm happy to. I just wanted to, it does have to do with this slide here. So whatever you choose.
Please go ahead.
Thank you so much. I appreciate this information. I wanted to know, do you happen to know in the work smarter, not harder type of realm, do we know if we're looking at the model that Deschutes has used and seeing the results do you know if that's being shared with like the Oregon Sheriff's group that is being able to educate more sheriffs in an effective way?
That's a very good question. Today was the first day that I heard about the program that the officer for Byrne PD developed, and I was curious if it had been shared as well. I don't have the answer to that question, Senator, but I know who would, and I'm happy to ask that question to our partners at the State Sheriff's Association and Chiefs of Police Association.
Perfect.
And
Thank
I
you.
can report back to this group.
Thank you.
And I've added Clackamas County into this as well. So similar to Deschutes, they started out with almost no, in fact, they had no ERPO cases in 2018. And their case counts have been rising as well, although not as much as Deschutes. They've had 16 cases through September of this year, and 14 of those were filed by law enforcement. And what we've seen year after year is that the majority of ERPO cases are filed by law enforcement. Jonathan had information in his presentation as well, and I have my information here through September. The law enforcement filings are in this dark navy. Bars, family or household member are in this kind of medium blue. And then the light blue is what we're calling the other category. And those are really the cases where the petitioner doesn't meet the definition, either as indicated in the petition or in a subsequent court document. They don't meet the definition of law enforcement or family or household member. We talked a little bit earlier about the standard for granting an ERPO, and there are certain risk factors that the court is required by statute to consider. When I first began tracking ERPO cases, I did track the factors for cases filed in 2018 and 19. We stopped doing that just because it became a workload issue, but it was, my takeaway from doing that work was that in almost all cases, there were multiple factors alleged in the petition. And that was a really important point because when the legislature was considering whether to enact an ERPO law, there was a concern raised during the legislative hearing that someone could lose their firearm rights based on a single risk factor, such as having a prior DUI conviction. And I think if this standard is otherwise met, the court could issue an ERPO based on a single risk factor being present. However, these cases are complex and usually involve multiple factors. The most common ones that seem to be cited involve a respondent with a history of suicide threats or attempts, history or acts of violence against other people, and acquiring or attempting to acquire deadly weapons within the previous 180 days. So courts that have considered a petition have granted an ERPO in about 79% of cases overall. And ERPOs are granted at a slightly higher rate than all protective order cases, which are around 70%. But the rate at which ERPOs are granted really varies widely by the type of petitioner. Overall, for law enforcement, it's at about 97%. Family or household members are at about 59%. And there have been some cases where a petitioner that falls within the other category, the petition was granted that occurred in 2019 and 2020. One thing that I don't know about those cases is that information could have been presented during the ex parte court hearing that may have changed whether there was a qualifying petitioner, but I can't ascertain that from looking at the document itself. Those are cases that are older and those orders would no longer be in effect. But looking at law enforcement and family or household members, very, very differing rates at which the ERPO is granted. And so why are there differing outcomes by petitioner type? And in looking through the case documents, there were some things anecdotally that appeared that may affect the rate at which certain petitioners file and are granted an ERPO. So some family or household members may end up filing another type of protective order as it could be more appropriate for their situation. So for example, FAPA not only includes the firearm restrictions, but the court can also issue no contact orders and temporary child custody and parenting time orders. There's also procedural considerations that come into play in these cases. Meeting that clear and convincing evidence standard could be challenging for non-law enforcement petitioners. In reading the petitions filed by law enforcement, it's not uncommon to see attachments that include supporting documentation like police reports, text messages, photographs. Another common reason that I have seen why a petition may be denied when the petitioner is a family or household member is the petitioner doesn't appear at the ex parte hearing. That is an automatic denial. Or the person does not meet the definition of family or household member. When those situations occur, there are, I would say, a handful of cases every year where the petition is then refiled. If it's a situation where the petitioner didn't appear at the hearing, you'll generally will see the same parties. If it's a situation where the person did not meet the definition for a family or household member, there may be some petitioner shopping occurring, trying to find someone that does qualify, and the petition is refiled. For purposes of our data and how we talk about ERPO cases, those are counted as separate cases, even though it's the same family or the same respondent. There could be other reasons that contribute to these differences as well, such as challenges in accessing the courthouse, lack of knowledge, and also limited law enforcement resources. I know some conversations that I've had with criminal justice stakeholders about this type of protective order. A representative from law enforcement noted that officers that handle domestic violence cases usually file the ERPOs because of the delicate and technical nature of these cases. So once the court issues an order, the respondent has 30 days to request a hearing. And although not part of my regular tracking at this time, I did, for this presentation, request some information at the rate at which respondents request a hearing. And for ERPO, it's about 25% of all cases. And compare that to all protective order cases, it's about 34%. Once the court holds a hearing on these cases, about 38% of ERPOs are dismissed, as opposed to 54% of all other protective order cases. And to give you an idea of what ERPOs look like, I wanted to share a couple of case examples with you today. I'm just intending to give you a very high-level overview of these cases just to preserve the anonymity of the parties, and because I think some of these petitions describe very traumatic incidents. So I just wanted to be mindful of that as we talk about these cases. All of these cases were filed in the third quarter of 2023. The first case was out of Deschutes County. It was filed by law enforcement, and respondent had recent incidents of domestic violence, attempted law enforcement assisted suicide, and threats of deadly force against law enforcement. The court granted that ERPO, and of note, there were related criminal, FAPA, and dissolution cases all filed within 2 weeks before the ERPO. The conduct underlying the criminal case and the FAPA and the domestic violence issues in the ERPO were all the same incidents. In Multnomah County, a respondent's former partner filed for an ERPO because there were recent threats of suicide and incidents of sexual assault, domestic and physical violence, and threats with weapons. A respondent used petitioner's credit card to make a purchase from a firearm manufacturing company, and the petitioner did not know what had been purchased. The court actually denied the ERPO in this case. However, that same day, the court did issue a FAPA. I confirmed it was the same parties. And I wanted to include this case in here just to sort of illustrate that sometimes, even though an ERPO is denied, a party may get relief through some other legal mechanism. So an ERPO may not be the vehicle, it may be something else. I have noticed in cases where it is a former partner or spouse that files the ERPO, those cases tend to have more domestic violence issues. When it is a parent, sibling, or child that files the ERPO, those cases tend to involve more threats of suicide. And lastly, in Washington County, law enforcement filed an ERPO because respondent had a history of self-harm, drug and alcohol abuse, and elementary and middle school threats by firearm. A respondent was arrested in April for breaking into an elementary school at night and made threats to kill family and burn down their house. And respondent was also associating with groups aligned with Satanism and Nazism, and particularly groups that would require you to commit some type of overt act to show your allegiance. And so law enforcement became very concerned about the escalation of respondents' actions, and the court granted the ERPO in that case. And as Jonathan mentioned, there are associated criminal penalties with ERPOs. It's a Class A misdemeanor to possess a deadly weapon prohibited by an ERPO. The chart here shows you all of the charges that have been filed since that law went into effect in 2018. I want to highlight the 15 charges in Clackamas County in 2022. That is all from one case, and each weapon that the respondent was illegally in possession of was charged as a separate count. In that case, the defendant or now respondent ended up pleading guilty to one charge, and the remaining 14 charges were dismissed. You could also be charged with a Class A misdemeanor for filing an ERPO with false information or with intent to harass the respondent. There have been no charges filed since that law went into effect in 2018. And I'm available if there are questions. My email is here. If you think of something after the meeting ends, please feel free to email me anytime. And Bridget has a copy of my slides, and she will be sharing that with you. And I just want to thank you for your time today.
Thank you so much, Kimberly. I see Representative Reynolds has a question.
Hi, thank you. Great presentation. Really interesting, and like seeing what works where. I had a question about that first case that you mentioned, that the family had, or the folks in question, and I must be thinking about this wrong, were already granted a FAPA, right? Wouldn't that mean that the respondent has to turn over their firearms? Was this just like a belt and suspenders thing, or is this, I'm curious why you would need both.
That's a very good question. So the timeline on that is that the criminal case and the FAPA were filed first on the same day. About a week later, the dissolution was filed, and then the ERPO was filed. So the FAPA and the ERPO have different parties. The petitioner is different in both. You do have the same effect of there's a prohibition on possessing and purchasing firearms in both. The FAPA gets you a little bit more, though, and it may have been a case where law enforcement was not aware of the FAPA when they filed the ERPO. There is nothing in the ERPO statute that prohibits the court from issuing an ERPO if there's an existing protective order in place.
Thank you. Yeah, that's great. And I'm all for, like, let's be as careful as possible. I was just curious if there's something I was missing there. So thank you.
Senator?
Thank you. Quick question. Is there a definition, and I imagine because that's a ORS, of deadly weapon?
There certainly is. It is, I've got it right here. It is in the ERPO statutes in 166525, Sub 1, and it defines deadly weapon as any instrument, article, or substance specifically designed for and presently capable of causing death or serious physical injury, or a firearm, whether loaded or unloaded. When I have read through these cases, I've only ever seen them talk about firearms. So when the petitioner is describing accessing weapons, they're talking about firearms. When we I haven't seen it applied to any other type of deadly weapon, but it could, legally it could.
Yeah, and I thank you for that. And in no way does this is this have anything to do with my own personal opinion as to how that is described. But I do think sometimes this may be sometimes where we get stuck in a urban rural type of kind of conversation when we describe the firearm as the deadly weapon versus, but some people have the mentality that it is used for something else rather than just calling it out and saying firearm. Right? I know that's like in the weeds, but I do sometimes think that's where we can get into people getting their shackles up and their defenses because they're like they automatically see the terminology. And I just wondered sometimes if that's, I don't know. Sometimes my brain just works in a weird, strange way, but I just wanted to point that out. No way does it, my personal opinion. I'm just thinking.
Senator Solomon, for an anecdote, my dad is from Alaska and was definitely raised with the idea that firearms are tools. So just to give a little anecdote as to what I think you're getting at. Do we have any other questions for Kimberly or John and Andrew on our presentations today? I'm not seeing any. Thank you all so much for those really helpful presentations. I will send out the slides to our members and interested parties so you can maybe dive in and see the graphs a little, if you need more time with them. If you do come up with questions, I certainly get you connected with all three folks to get those answered. And I do have a list of some of the things to track down for next meeting. Looking at the clock, I want to leave a moment for public comment and any other member questions. I see a hand from Liddy Ballard. Liddy, go ahead.
Hi, thank you so much. I apologize for my voice and staying off camera. I'm not feeling great, so I'm going to spare everyone. My name is Liddy Ballard, and I am a state policy manager at Brady. And my team and I have had the distinct pleasure of working alongside advocates, survivors, partners, and elected officials to reduce gun violence through evidence-based policies here in Oregon. And I thank you for the opportunity to provide public comment on the Byrne intervention program in Oregon. Today, I would like to respectfully urge you to invest a portion of this funding for public education campaigns around safe firearm storage and extreme risk protection orders. Evidence has shown time and again that it is crucial to take action to address the public health crisis of gun violence, and one of the best ways to do it so is to invest SCIP funding in public education and awareness campaigns. Oregon already has a strong foundation in its current laws regarding extreme risk protection orders, but utilization, and I learned a lot more about it today, does remain relatively low compared to some other states. Ensuring public awareness of the state's ERPA process will increase its utilization and reduce gun deaths, as previous presenters today mentioned. While safe firearm storage is an effective tool to reduce gun violence, research shows that a large percentage of gun owners across the country do not store their firearms safely. Polling has shown that although 70% of parents reported that adolescents could not independently access firearms in their household, over 1/3 of children belonging to those households reported being able to access the firearm in less than 5 minutes. And tragically, 92% of guns used in accidental shooting deaths among children were left unlocked and loaded. Comprehensive public education campaigns are effective for increasing awareness and utilization of safe firearm storage practices and in reducing gun violence as a result. Previous public education campaigns have proven successful. 48% of gun owners who saw Brady's End Family Fire campaign ads about safe firearm storage changed how or where they store their firearms to store them in a safer manner. As this board develops its plans for the Byrne Skip funding, we urge you to invest at least 10% in public education campaigns to reduce gun violence in Oregon. Thank you for your consideration of this request. The impact of this historic federal funding is in the hands of decision makers like you. Thank you for your time.
Thank you, Liddy. Do we have any other members of the public who would like to comment or ask a question today? I'm not seeing anyone. So in our last few minutes, I want to just note that our meeting, I brought this up at the very beginning, but for folks who maybe joined a little late, our next scheduled meeting is for Monday, the 27th of November, and that is the day after some folks celebrate Thanksgiving. So I don't know if this will interfere or if travel plans, if we might have some attendance issues. So what we're going to do in between now and then is reach out to you all and see if you are available still on that day. And if it looks like we might have, fewer folks than ideal, we'll probably try and bump that to a little bit later in, early December, because having you all here is very important. And then secondly, for that meeting, one of the goals is to go over, like Senator Solomon brought up earlier, kind of what already exists to the extent we can track down, both grant programs and other initiatives, to just see what the lay of the land is. And last but not least, to the extent possible, other programs, either community-based programs, court programs, or law enforcement safe storage tracking programs to get more information about those. Lori, I see you have a question. Go ahead.
Thank you for allowing me to talk. I'm Lori Palmer, and I am the founder of Go Get Your Child. And basically, that's a program where I work with families that are affected by violence. I've been doing that for over 8 years, and I work with mothers, African-American mothers that are affected by violence. And there is no program, there is no investment in African-American mothers. And I would like to see an investment in that. We actually just got a table now where we can start having some healing circles. So I will be bringing some information to this table. But I would like everybody on here to take a look at that. I enjoyed all the information here, and all this information is good. And we need to do all this work. But there is no investment in African-American mothers. And they are the womb of the children that's out there dying. And we have to go get them. And in this work, I went and talked to these mothers. And I have mothers. And they are lost. And they don't know about gun violence. They don't know nothing about none of this education. They need to be on these calls. And we got to go get them and educate them so that they can educate their families, as well as we can educate them and boss them up. I call it bossing them up, giving them education and training them up and healing them and getting them ready so that they can be ambassadors in their community. We need to invest in these mothers. Thank you.
Thank you, Lori. And I'd be happy to follow up with you to see if we can learn more about that program in this forum later on. So thanks a lot for bringing that up. Do we have anybody else with a comment or a question before everyone gets on with the rest of their Monday? All right, I'm not seeing any new hands. So thank you all very much for your time. Thanks for our presenters. Really, this is a really active and engaged group, and I really appreciate that as the staff. So thank you all, and we will talk to you all soon. Thank you. Have a good one.